Afternoon. My name is Henry Quillian. I'm here at Taylor English with my colleagues discussing litigation matters that are of grave importance to attorneys and to their clients. At Taylor English, we are not providing legal advice in Quillian's kernels, aka Litigation Fundamentals, but we are providing information that you can share with your attorney if you're not an attorney, or if you are an attorney. Please do your own research and make your own decisions regarding how you're going to handle matters. Today's topic is regarding the prohibitions against shotgun pleadings, which in some federal circuits are referred to as kitchen sink pleadings. And we will walk through what those are, how devastating they can be to your case if you are a plaintiff or if you are a defendant who has participated in shotgun pleading, and how to avoid, if you can, a determination by a trial court and ultimately an appellate court that your pleadings that have been filed with the court are indeed shotgun pleadings and not worthy of being in court, because the ultimate outcome of a full shotgun pleading objection that comes to full fruition is a disappearance of your pleadings and a dismissal of your suit or a striking of your answer. I am going to launch a paper that sort of helps walk through this subject matter, and we will take a look at where this came from and where we need to go with it. So this all came starkly to my attention in a matter where I was defending a case that you will see is now on petition to certiorari to the U.S. Supreme Court. And in an order striking the amended complaint of 16 plaintiffs seeking nearly $30 million, the district court stated, as already explained in this court's March 22nd, 2019 order, which had struck the complaint by a previous judge assigned to the case, courts in the 11th Circuit have little tolerance for shotgun pleadings. And it cited the Vibe Micro case, which will come up several times during this discussion. Typically, shotgun pleadings are characterized by multiple counts that each adopt the allegations of the preceding counts, conclusory, vague, or immaterial facts that do not clearly connect to a particular cause of action. That type of facts often found in pro se complaints and in complaints, of course, filed by lawyers. Failing to separate each cause of action into distinct counts, or combining multiple claims against multiple defendants without specifying which defendant is responsible for which act. Now, here at Taylor English, we are in the 11th Circuit of the U.S. courts, but we have prepared a paper and a survey and find that virtually every circuit applies some version of shotgun pleading or a kitchen sink pleading rule that addresses these objections to pleadings. The most prevalently cited 11th Circuit case nowadays is the Whelan versus Palm Beach County Sheriff's Office case from 2015, but there have been numerous cases that have come about since that case, many of which dismissed plaintiffs' complaints. Now, that description of shotgun pleadings is relating to complaints. However, a word of warning, the exact same thing applies to defensive pleadings, and in particular affirmative defenses or other pleadings filed in an answer that suffer from the same type of problem. So in this case, the district court order went on to say shotgun pleadings waste scarce judicial resources, exorbitantly broaden the scope of discovery, wreak havoc on appellate court dockets, and undermine the public's respect for the courts. That's a 2018 case. And then there's a quotation from a 2018 case, shotgun pleadings, whether filed by plaintiffs or defendants, exact an intolerable toll on the trial court's docket, lead to unnecessary and unchanneled discovery, and impose unwarranted expense on the litigants, the court, and the court's parajudicial personnel and resources. Moreover, justice is delayed for the litigants who are standing in line waiting for their cases to be heard. The Court of Appeals and the litigants appearing before them suffer as well. The 11th Circuit even stated that tolerating shotgun pleading constitutes toleration of obstruction of justice. So, therefore, because of the horrors that shotgun pleading caused the courts, and in the specific case we're involved in, the district court struck the plaintiff's amended 258-page, 52-count complaint. Now, that was the amended complaint that was filed after the trial court and by a previous judge, and a previous order striking the complaint gave specific directions to the plaintiffs regarding how they were supposed to replead their complaint. This holding was affirmed at the 11th Circuit and is now in petition for certiorari to the U.S. Supreme Court by the plaintiffs. Why? How did this happen? Well, the courts look at the pleading rules set out in the Federal Rules of Civil Procedure, and then they apply a whole series of cases by the U.S. Supreme Court and by the preceding 11th Circuit, in this example, Court of Appeals decisions. So it's important for us to look at Rule 8 of the Federal Rules of Civil Procedure. And of course, if you're old like me, you recall that the Federal Rules of Civil Procedure were supposed to implement notice pleading, and were supposed to be a replacement of the demurrer and other stricter pleading rules of the old days. And so Rule 8A2 says that a pleading that states a claim for relief must contain a short and plain statement of the claim showing that the pleader is entitled to relief. And if you're talking about an answer, in responding to a pleading, a party must state in a short and plain terms its defenses to each claim asserted against it. And the short and plain language obviously is something that the appellate courts have seized onto, and the trial courts have seized onto in eliminating shotgun pleadings. There's an overlay of Rule 10b to these pleading requirements. And they are that a party must state its claims or defenses in numbered paragraphs. That's easy enough. Each limited as far as practicable to a single set of circumstances that might be violated fairly easily. A later pleading may refer by number to a paragraph in an earlier pleading. If so doing would promote clarity, each claim founded on a separate transaction or occurrence, and each defense or other denial must be stated in a separate count or defense. So that goes to one of the four bases that shotgun pleadings can be found. Now, the question arises, if you're looking back at history, Conley versus Gibson says the Federal Rules of Civil Procedure reject the approach that pleading is a game of skill in which one misstep by counsel may be decisive to the outcome, or accept the principle that the pleading is to facilitate proper decision on the merits. So like I said, when I came through law school, the Federal Rules of Civil Procedure were a real relief for lawyers who were having their cases thrown out of court because they didn't skillfully plead. But as we all know, in 2007, there was an overlay of the Twombly and Iqbal cases. Iqbal followed Twombly, and we'll look at it in a minute, issued by the U.S. Supreme Court. And I'll just read this because basically the Supreme Court words are all important in understanding what additional layer of pleading requirements the Supreme Court, in interpreting Rule 8 and Rule 10, applied to pleadings in a complaint. The Twombly complaint in this instance was a antitrust complaint. And it said, while a complaint attacked by Rule 12b-6, motion to dismiss does not need detailed factual allegations, a plaintiff's obligation to provide the grounds of his entitlement to relief requires more than labels and conclusions. And a formulaic recitation of a cause of action's elements will not do. So you can't just repeat what the courts have said are the elements of a cause of action. Factual allegations must be enough to raise a right to relief above the speculative level on the assumption that all the complaint's allegations are true. Applying these general standards to, of course, it's going directly to the complaint in hand, stating a claim requires a complaint to be enough factual matter to suggest an agreement. Asking for plausible grounds does not impose a probability requirement at the pleading stage. It simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of an illegal agreement. Like I said, it was an antitrust case. The need that at the factual pleading stage for allegations plausibly suggesting, not merely consistent with, agreement reflects Rule 8A2's threshold requirement that the plain statement possess enough heft to show the pleader is entitled to relief. A parallel conduct allegation gets the Section 1 complaint close to stating a claim, but without further factual enhancement, it stops short of the line between possibility and plausibility. Iqbal supplemented that in 2009 by saying that under Federal Rule of Civil Procedure 8A2, a pleading must contain a short and plain statement of a claim showing that the pleader is entitled to relief. The pleading standard Rule 8 announces does not require detailed factual allegations, but it demands more than an unadorned, the defendant unlawfully harmed me accusation. A pleading that offers labels and conclusions or a formulistic recitation of the elements of a cause of action will not do, nor does a complaint suffice if it tenders naked assertions devoid of further factual enhancement. To survive a motion to dismiss, a complaint must contain sufficient factual matter accepted as true to state a claim to relief that is plausible on its face. A claim has a facial plausibility when a plaintiff pleads factual content that allows the court to draw a reasonable inference that the defendant is liable for the misconduct alleged. I'll discuss a series of cases we got dismissed a couple of years ago under that sentence. The plausibility standard is not akin to a probability requirement, but it asks for more than a mere sheer possibility that the defendant has acted unlawfully. Where a complaint pleads facts that are merely consistent with the defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. In the example of that sentence that says a claim has factual plausibility when a plaintiff pleads factual content that allows the court to draw a reasonable inference that the defendant is liable for the alleged misconduct, does have that word reasonable in it. We had cases in 2018 that alleged false advertisement by a series of convenience stores who placed products on their shelves that allegedly contained false information on them. And repeatedly, multiple times in multiple district courts, we got those complaints dismissed on the grounds that even with everything the plaintiff said, it was totally unreasonable for the the court to conclude that at the end of the day, the convenience stores were going to be able to be shown to have known about any factual misstatement on the labels on the products in their shelves. So that was the first set of cases I actually succeeded getting dismissed on plausibility grounds. So it's not necessarily a omnipresent situation that you can bring such a motion to dismiss. And you certainly hope it's not a plausible, it's not an omnipresent situation where you have shotgun pleadings. And also, you know, just for the record, obviously I do as much plaintiff's work as I do defense work. So I do have to deal with pleading in a complaint. I guess I would say just the right amount of facts. Now, when I came through, I was always told to plead thin to win, which essentially means stating enough to get your cause of action before the court, but don't state more where you might be making allegations that end up being unprovable, or making allegations that ultimately are used to cross-examine your client successfully. When you can avoid saying more, you should avoid saying more. But if you have to say a certain amount, then you say what you have to say. And that's the real trick when we're talking about shotgun pleadings. There was a district court in Wisconsin that came up with a rule that seems to make sense to me as far as analyzing your own pleadings. And it said, after Iqbal and Twombly, court assessing sufficiency of the complaint should ask, if all facts the plaintiff alleges in his complaint are accepted as true, but all conclusions are rejected, is it still plausible that is more than speculative to believe that that additional discovery will fill in whatever gaps are left in the complaint? So the focus, obviously, of that district court was the conclusions that plaintiffs are prone to put into their complaint, such as all these the activities of the defendant defrauded the plaintiff and were unacceptable under any view of acceptable conduct, or something like that. That it's just a conclusion, it's not a fact. And if you truly were pleading thin to win, you would just state who the plaintiff was, the defendant is, who the plaintiff is, who the defendant is, what the jurisdiction is, and a bunch of legal conclusions. But that will not carry the day under Iqbal or Twombly. You do have to have sufficiently identifiable facts in your pleading. But of course, we run across the situation of fraud and mistake-based cases, because Federal Rule of Civil Procedure 9b says, in alleging fraud or mistake, a party must state with particularity the circumstances constituting the fraud or mistake. And generally speaking, the case law has said that needs to include the who, when, where, what, and how regarding the communications or the other circumstances giving rise to the fraud or mistake. It can't be just a conclusion. And that would tend to lengthen a complaint and make it more filled with individual facts. And if your initial allegations in the complaint have the facts, and then subsequent to that you have the counts, under the shotgun pleadings rules, you need to take care to tie the facts that support each count to the underlying factual allegations, so that you avoid the objection that all the preceding facts are incorporated into a count when they shouldn't be, because they don't actually tie to the cause of action that the count is seeking to assert. And if you have multiple defendants, you got to take the additional step and worry about making sure that the facts associated with the liability or claim for relief against each defendant are properly segregated, so that, as we'll see in a minute, the notice to the defendant requirement that's inherent in Rule 8 and Rule 10 is adequately accomplished, followed. So in our case, the 11th, what happened was Judge Totenberg struck the complaint on the motion of a number of the defendants. However, I'll note that a number of defendants did answer the complaint and did not move to strike. Our client moved to strike and also filed a motion, some very targeted motions to dismiss based on the express allegations of the complaint. And Judge Totenberg, however, struck the entire complaint, which I think was 198 pages at the time. Same general set of plaintiffs, and then about 25 defendants. And in her order, she told the plaintiffs, you have the opportunity to replead. Now, that is a fundamental requirement. If you ever have a complaint stricken on the grounds that it's a shotgun pleading, make sure that you insist that the district court give you an additional chance to plead, because under the Bob Micro case that I mentioned just a few minutes ago, the 11th Circuit has expressly said that an opportunity to replead must be given to the plaintiff's counsel if a complaint is stricken and dismissed with prejudice. So Judge Totenberg specifically ordered that the complaint be broken down such that the counts showed each defendant that was subjected to each count, that each subsequent count did not incorporate all the preceding counts, and also most especially did not incorporate all the preceding allegations of fact, so that presumably the facts that are go to each count are specifically incorporated by reference in the count, and that all the other facts that don't relate to that count are not incorporated in that count. And the complaint ended up being 258 pages long, but essentially the plaintiffs did not eliminate any of the statement of facts. And one of the problems was that some of the individual paragraphs in the complaint might have been a page long or half a page long, with numerous sentences about a lot of different people doing a lot of different things. So the 11th Circuit, in reviewing the record, the subsequent to that, Judge Totenberg transferred the case to Judge Boulay when he got on the bench, and then Judge Boulay entered an order again dismissing the complaint, amended complaint with prejudice, and then subsequent to that denied a motion for reconsideration, dismissing the complaint with asking for a reversal of the dismissal of the complaint with prejudice, and also asking that all the state law claims that had been asserted be dismissed without prejudice, so that the plaintiffs might pursue the state law claims in the state court, where they wouldn't be subject to the shotgun pleading rules, except to the extent the state court might adopt such rules. So Judge Boulay stated that Judge Totenberg had thoroughly explained to the appellants why the original complaint violated the shotgun pleading rule and provided notice of the defects. However, the 11th Circuit, in describing Judge Boulay's order, said, however, the appellants did not meaningfully amend their original complaint. Judge Boulay determined that they should not be afforded another opportunity to amend. Thus, the court granted the motions to dismiss on the shotgun pleading grounds and dismissed the case with prejudice. Well, that particular case originally had federal RICO claims, federal securities fraud claims, and a whole lot of state law RICO claims and state tort claims of various types, including fraud, conversion, various equitable claims, etc. And Judge Totenberg had held in the first motion hearing, or first order, that the plaintiffs could not submit federal securities fraud cases alongside federal RICO cases, because federal RICO could not be used as a grounds for federal security fraud. So she had already stricken the federal RICO claims, and so those were gone, yet the complaint ended up being 258 pages instead of 198 pages. And so Judge Boulay determined that they simply did not thin down the complaint like they should have, and did not take the necessary steps to break it out per defendant, etc., and dismiss the entire case with prejudice, including all the state law conversion, RICO, and equitable claims. The 11th Circuit affirmed, and it stated in so doing, that shotgun pleadings violate Federal Rule of Civil Procedure 8A2 short and plain statement requirement by failing to give the defendants adequate notice of the claims against them and the grounds upon which they rest. Each claim rests. And that seems to be the most important thing, is the courts feel like that if there's way too much chaos, for lack of a better description, in the complaint, that the defendants, despite notice pleading being the rule, do not have enough with ability to segregate out what is specifically asserted against that defendant versus another defendant, or what is specifically gives rise to one cause of action or claim versus another. Again, it cited the Bob Micro case. The court, meaning the 11th Circuit, like the two district court judges before it, has now engaged in the painstaking task of wading through and deciphering appellant's tangled mess of allegations. After that review, the 11th Circuit Court concluded that the district court did not abuse its discretion in striking the appellant's original complaint or dismissing the appellant's first amended complaint, shotgun pleadings. Okay, so that is bad for the plaintiffs, as we might understand. So what have they argued, and what is a standard set of arguments, I guess is one way of putting it, as to the reasons why shotgun pleading standards should not be applied in the 11th Circuit or in any other circuit. And I believe they are applied in virtually every circuit, but I think the 8th Circuit might call them something different. And the 9th Circuit may or may not have shotgun pleading rule. Have to check my tables. What do they argue? What do they argue in response to this to try to disabuse the courts that they have violated the shotgun pleading rules, which of course ended in this outcome that is highly unfavorable to the plaintiffs and to the plaintiffs' lawyers? First of all, they say, well, our complaint is all founded on fraud and other specific facts. And in order to state these 52 counts of liability, we have to say more. We have to have more facts. And in order, I guess they would add to that, but I'm not sure they expressly argued it, that the paragraphs in which the facts are stated have to place the facts in the context of other facts in order for a reader to see why those facts had the impact they did on the plaintiffs. And they might argue, well, it's not the plaintiff's fault that the defendant created a complicated fact pattern that has to be written up in a complaint. Now, they will also argue, and this is something to consider if you are a recipient on behalf of a client of a shotgun pleading, as we were, whether you should answer the complaint or whether you should just move to strike and not answer, or move to dismiss on some, I'll call it, rather than shotgun, rifle shot grounds instead of answering the complaint. Because the plaintiffs will argue that because a defendant answered, they had notice, and if they had notice, that Rule 8 and Rule 10 guidelines were satisfied. Similar, they may argue that if a defendant did a detailed motion to dismiss each allegation against the defendant, other than on sort of plenary grounds, the ones that saying, let's say it be a defendant said, hey, now wait a minute, I never had anything to do with any of this, or the plaintiff hasn't alleged the correct name or something, or it's named a corporation when it should have been an individual, or something that applies to the entire complaint, then the plaintiff may argue, well, the defendant filed a motion to dismiss, so it must have had notice of the claims against it. And then also, the plaintiff will say, hey, well, the second time I pled this complaint, I only incorporated the first 300 preceding allegations. I didn't incorporate the 450 preceding applications into each count. And so therefore I followed the rule that you're not supposed to incorporate all the preceding allegations in each successive count. So that would be an argument that has been made and was made in our case, and that might be made by a plaintiff who is trying to wiggle out of the dismissal. And then they will say, well, multiple defendants maybe were involved with each cause of action. So we broke down the counts and we did state which defendants each count was against. But in doing so, they very well could violate the other rules of incorporating way too many paragraphs into each count, or common failure of many pleaders is incorporating counts that are actually contradictory to the count in which they're now pleading, such as if you plead an express breach of contract count, you shouldn't plead a quantum meruit count for the exact same recovery under the exact same set of facts. If you have an express contract, you can't have a quantum meruit claim. So, and this is the one that they're taking to the U.S. Supreme Court. They're saying, oh, we're this sort of putting aside, did we do anything right or anything wrong? Because now we've had 2 district court judges and the 11th Circuit say we did it wrong. So that to the U.S. Supreme Court, they're saying the entire shotgun pleading standard, especially as implemented by the 11th Circuit, is an impermissible new standard that illegally displaces Twombly and Iqbal. And so the Supreme Court, along with the Federal Rules of Civil Procedure, has announced what the rule is for pleadings in the federal district courts. And the shotgun pleading is a rule that doesn't have judicial sanction by the U.S. Supreme Court. And so no cases anywhere should be able to be dismissed on a shotgun pleading ground, as earlier discussed. And they'll also argue, and have argued, that dismissal with prejudice is unfair to the represented plaintiff and gives rise to unwarranted malpractice claims against the attorneys. Now, as was stated in the motion for reconsideration in our case, they state that the state law claims should not be dismissed with prejudice. They should be dismissed without prejudice if the district court doesn't want to hear the complaint. And they say that's especially true when the state law claims are in the case solely because of pendant jurisdiction, but the district court has dismissed the federal question jurisdiction claims. So the Vibe Micro case should be looked at because that is a ruling by the 11th Circuit in Vibe Micro that if the state court claims are only in the federal court because of the federal question jurisdiction claims which have been thrown out, then the dismissal of the state law claims should be without prejudice. And of course, what that suggests, however, is that there's not alternative federal question, original jurisdiction in the district court over the state law claims, such as in a purely diverse set of plaintiffs and defendants, and especially where the plaintiff has expressly alleged diversity in jurisdiction in addition to federal question jurisdiction. And in our case, they allege both federal question jurisdiction and diversity jurisdictions. And even though there were a gazillion parties, I think it's around 40 involved between the plaintiffs and the defendants, and some of those were LLCs, there was complete diversity. So that lays out the problems and the issues and the arguments you will face. And I think the conclusions we can discuss, or the things we can discuss about how to avoid these problems, relate to the amount of preparation and time we put into crafting our pleadings, so that we don't, nothing we ever do encounters such an objection. And if we do encounter such an objection, then we want to have the arguments at hand to counter that objection before the district court ever makes a conclusion. And that, of course, can be by way of either amending the complaint or moving to amend the complaint if that's necessary, and filing a thinner complaint that still achieves the Rule 8, Rule 10, and Rule 9B requirements. So that was a whole lot, but there's certainly some to be discussed amongst us on this subject matter, because it's our goal and our duty to try to avoid problems wherever we can in undertaking our legal actions. And so I will open the floor to discussion among anybody that wants to raise an issue about what's been presented, and whether you have, hopefully you don't, I'm not aware of anybody else in the firm having specific experience with this, but Molly, if you can control allowing people to ask questions and discuss it. I see Mark coming on, several people going on unmute.
I just saw, honestly, Tamara called me about some stuff with our depositions. And so I have not been listening for about the last 5 minutes. I just saw it said Henry wanted me to unmute, so I unmuted.
Okay. Well, in that case, if you have a case where Mark Carter is working with you and you have a shotgun pleadings situation, Mark, watch the last 10 minutes of the first part of Quillian's kernels.
We actually had that with a case I had with John Richard about, it was probably a year and a half ago, where we got dismissed because we were defending it as a shotgun pleading. And John Richard, who's no longer here, did a really good job with that and identifying the issues and briefing it up and got everything dismissed. So ultimately got dismissed. They were given the opportunity to as you stated earlier, to fix the problem, and they didn't fix the problem. They didn't even, I mean, the court in that case even gave them an outline of the problems, kind of like a bullet point by point outline of the problems in the pleading and how to fix it. And all they did was copy paste and add a couple of additional variants. And then on the motion to dismiss, court took them to task. And I think that was Totenberg, if I remember correctly.
How about that? Well, and so what do we learn from that? A really common experience. And I think that's that you should not doggedly resist a judge's admonitions to do something different.
Well, that should be a that should be a guiding principle for lawyering at every level. Is to not resist. If a judge is telling you to do something, then by all means do it. But there seems to be what I've seen. There seems to be some sort of dogma with attorneys with they know better about pleadings and not taking some of these admonitions seriously and not taking shotgun pleading seriously because, well, that's how we've done it for 30 years. And the court, especially in the Northern District, takes a very dim view to that kind of thing. And I have in the last few years have seen certain state court judges start bending towards the Northern District. Northern District's position on shotgun pleadings. And while notice pleading is certainly Henry's thin to win strategy is the norm in state courts, we have taken a couple issues to state courts and gotten some relief on for the other side to amend pleadings. But without the strict admonitions and consequences of potential dismissal. So there might be some judges might be moving that way.
Yes, that's sort of an observation I made. Is I'll say oftentimes it's newer state court judges who have been around the block as a litigator for a long time will often implement scheduling orders, discovery, dispute resolution orders, and a lot of other types of discipline type orders that have originated apparently or seem to have originated in the district courts.
Yep.
And there was just remember for the paralegals and younger attorneys that are on is there's often always, well, not always, but very often an alternative to a resolution, such as if you filed a very thin complaint in state court and the defendant says it's too thin, then they may move for dismissal under Rule 9B if it's a fraud complaint. But there's a very, very high probability that the court will take that as a motion for a more definite statement or
right.
And allow repleading. Now, and oftentimes in the interim, you'll get additional information, such as in the state court, if the defendant has to answer, you might actually then have admissions by the defendant that you can use in your pleadings and on the amendment.
Right.
Or you might get discovery in the interim as well. It's less likely now that you get a stay in state court if you file a motion to dismiss for a period of time.
Right.
So Mike Cicero has a comment. He says, can you incorporate the same, and it closed out on me. Can you incorporate the same set of factual allegations, paragraphs in different counts without running afoul of the shotgun pleading prohibition? In other words, would it be okay so long as you do not incorporate the paragraphs of any preceding count? Well, first of all, Mike, feel free to get off mic and discuss that with us. I'm off mute. And I think the answer is, of course you can incorporate the preceding allegation counts relating to who the parties are. So there's no way that's going to be prohibited. You can, if it's a fundamental fact, like let's say that's a contract that's being alleged in the preceding count, then that might apply to a number of different causes of action down the road. And I think that the argument comes up where the court cannot look and see what facts are against which defendant associated with that particular count that's mentioned later in a complaint that's substantially longer than the court would like to see, I guess is one way of putting it. How about some other questions, comments? Paralegals, have you ever called out the attorney and said, hey, this looks too much? Or alternatively, Mr. Attorney, Ms. Attorney, I'm reading this and I don't understand it. I don't see any way the court's going to understand it. Because remember, oftentimes our paralegals see complaints the first time, just like the court's seeing it the first time, whereas the attorneys involved might have been thinking about the underlying factual situation for a long period of time, and they could be sort of blind to the fact that everybody else doesn't have the context or the understanding. Has Mylene ever called the attorney to the table and said, you need to think about redoing this?
I don't think so.
Well, would you do it if I'm making a mistake and shouldn't be filing something that to you looks bad?
Of course I would, but
okay, good.
very diplomatically.
I'm sure. And I'm sure Mylene would affirm she does it's best and it gives her a better opportunity to assist if this isn't done at the very last second before the statute of limitations runs.
Of
In
course.
other words, if the pleadings are prepared a week or more in advance of when they need to be filed, it gives everybody more of an opportunity to hone down on what's really necessary in the complaint, or alternatively in the answer. Has anybody experienced a situation where an answer was attacked for being a shotgun pleading? I can tell you I have not, but I have on the flip side seen answers that list literally every known to Black's Law Dictionary affirmative defenses. And to me, not only that is that a waste, it puts the defendant, especially in cross-examination, into a world of hurt when they can't explain a single fact that supports the long list of affirmative defenses that the lawyer has just simply thrown in. And I think it's worthy of consideration of a motion to strike the answer if it's clear that the kitchen sink has been thrown in on the affirmative defenses. Lots of times you see that there's just a breach of contract count and the defendant pleads comparative negligence or something, which is just a waste of paper and a waste of time.
Henry Smart, I haven't seen that. I have seen it, but haven't taken it up. I had one answer filed in a case about 10 years ago that just had a single paragraph that says defendant denies every single allegation in the complaint, and that was it. Mm-hmm. Now, we were already in discussions about settling, and we had filed the complaint in order to preserve our statute of limitations issue. So we ended up settling it. So it didn't. I don't know if that was his normal way of pleading, but I never brought it up. That's the worst I've seen. But you're right, and this is something that would be a teaching point if you're drafting answers, and that is how you properly plead the defenses, because you can go. I have seen things like you're talking about with defenses that absolutely have no basis, and and it frustrates me when I see it.
Right, and
Hey, Henry?
yes.
Hey, this is John Rezac. I think typically from the plaintiff's side, you get one of those crazy answers, and you just kind of go on with your case. You move on to your discovery and all. But is there, if circumstances warrant, what might a plaintiff's counsel do in that situation where the answer includes a kitchen sink's worth of defenses, many of which don't apply to the case at all?
Well,
John, this is Mike Cicero. There was a recent decision by the Northern District of Georgia where the plaintiff, in view of a non-responsive answer, moved to have his allegations deemed admitted, and actually the court granted that motion. That was the first time I've ever seen that kind of a ruling, and so that's one option that is possible that I had not been aware of before.
and Mike, was that a ruling? And I think that's the case you sent to me that I haven't studied yet. Sorry about that. But was that a ruling for all purposes within the case? In other words, it was sort of a permanent, almost like a stipulation that whatever the defendant said is now admitted for all time?
I believe it was I think it was a trademark case. It was an IP related decision, and I don't, sitting here right now, I don't recall whether they parsed certain admissions having a permanence to them. My best recollection is that it was kind of a permanence effect on everything that was affected by on every deficient response was met with the court deeming them admitted. I'd be happy to recirculate that case to everybody so that they can read it for themselves.
Yeah, that would be great. And I would have a supplemental answer to John Rezac's question, which is it's a violation of Rule 11 if you're in federal court, to assert a whole bunch of defenses that have no foundation in fact. And so you would obviously have to spend the time and money to file and serve a Rule 11 motion. And then if you're in state court, you could send out a 915-14 warning or a 51-780 warning. And then motion wise, you can move to strike, I think under Rule 12F. Defenses that clearly have no applicability to the case between the parties. So I was going to actually separately ask John Rezac whether he's seen shotgun pleading rules applied in bankruptcy court.
I don't know. I can't recall offhand shotgun pleading rules, but Twombly and the other one we're always talking about. Particularly, it comes up with fraudulent transfer actions. The fraudulent transfer statutes have a true fraud section and another section that's constructive fraud. But in the true fraud portion, we frequently see motions to dismiss, for failure to sufficiently plead, and the Twombly standard is, what applies.
Okay, well, let us know if one all of a sudden pops up in bankruptcy court along the way.
Will do. Well, I did have another question, Henry, about the the incorporation of paragraphs. What we've been doing is, if you have 8 counts and count 1 begins on paragraph number 100, you don't have the first paragraph of each 8 counts saying plaintiff incorporates paragraphs 1 through 99, as if fully stated herein. Instead, you would say plaintiff incorporates paragraphs 1 through 12 and 32 through 47, and only include those paragraphs that are going to apply to that particular count. Is that the correct procedure?
I think that is the correct procedure, and the only thing that could potentially mess that up is if any of those paragraphs covered that are incorporated cover a whole lot more than one. I think the rule referred to it as particular set of circumstances, something like that. So that if you had one factual allegation that covered a car wreck and a breach of contract and a theft, then I guess the incorporation of any particular factual paragraph could run afoul. But I think if the courts see that you have truly honed the complaint down to the best and most concisely stated effort you could get, then you've got a pretty good argument. And if the court doesn't see it that way, well, then I guess what you can do is eliminate some of the counts and then get some discovery and then move to add them back in. Or do something where you actually have the hard facts for each specific count, by way of admission from the other party or something.
Yeah, your comment about you think the court, if the court sees that the plaintiff's counsel made a good, honest attempt to designate the right paragraph, so they're probably going to be lenient. I think that's a good thing to remember. The judges are human. It's kind of like a few weeks ago we were circulating those cases on the stock answer. The document speaks for itself. Mm-hmm. And a number of the judges that I've seen comment on that. What they're really upset with, it seems, is lazy lawyering. And I think if a lawyer's making an honest effort to answer and to have his client participate as it should in the pleading part of litigation, I think judges are going to be reasonable. You agree?
I think that's an important thing. Judges are not out to kill lawyers or their clients. They're out to try to control one, apply the rules in the case law. Two, try to control their dockets and keep their workload within a realm of reason. And that goes all the way up the system, of course. If they've got a case that's just a huge mess, if they don't get it under control early, then it's going to be a mess forever. While I'm on, we've just got a minute or two. I'll mention two things. One, I'm wearing my Federal Bar Association tie. I will give a plug for that. That gives you the opportunity to meet judges on a regular basis. And maybe if they're not going to do anything for you because they know who you are, but or if they know you personally, but they will perhaps give a better or a more detailed order saying exactly what you need to do to save yourself if they think favorably enough of you as a person that they won't want to obliterate you by dismissing your client's complaint with prejudice. And then I'll also mention that Riviere Duffy is on. She was our summer associate last summer. And tell us what you wrote about in connection with shotgun pleadings, Riviere.
So I wrote about the differences, or I guess more the similarities among circuits, and what the standard was in reference to shotgun pleadings, and then whether that differed if it was brought under original jurisdiction, the state claims, or through federal question jurisdiction.
Yes, and she prepared some detailed charts that are sort of a matrix you can work through, and depending on what circuit you're in, as to what the proclivities are of courts in that particular circuit to dismiss or not dismiss, or alternatively to mandate an additional opportunity to amend the pleadings, and then whether or not state law claims will be dismissed with or without prejudice. So that's a resource we now have available because of Riviere, who is also still working with us, correct?
That's correct.
and she is starting a Federal Bar Association student chapter at Georgia State. So we're excited about that. As y'all know, I'm a big advocate for the Federal Bar, so hence I give them my plug. Okay, that's about all the time we have today. Thanks for everybody being here, for your participation. Let's all work together to make sure that we don't run afoul of these rules, or that we save ourselves if we accidentally do. So have an excellent afternoon. Look forward to seeing you soon.